So Ask Resource Center is glad to welcome our presenter, Emily Ehlers.
Hello. Hello, everyone. Can everyone hear me? Sarah, can you hear me okay?
Yes.
Perfect. All right. So thank you so much for having me today. I am Emily Ehlers. I am the Systems Change and Equity Attorney with Disability Rights Iowa. As Sarah shared earlier, we're going to talk about notices of decision and Medicaid appeals and some tips and strategies that I have kind of cultivated and put together over my last about 7-ish years doing Medicaid work. I've been at DRI about 8 and have been doing Medicaid focused work a lot of that. So I've picked up a lot of tips and strategies that I hope can be helpful. So first things first, I always just like to share a little bit about the wonderful organization I work for in case you're not familiar with Disability Rights Iowa. Our mission is to defend and promote the human and legal rights of Iowans with disabilities. We are an independent, nonprofit law center. We are not a state or federal agency. I could probably give a whole presentation on the origin of protection and advocacy agencies across the country. There is one of us in all 50 states and US territories. But in short, in the 70s, a massive expose was done by a reporter in New York State uncovering systemic abuse of individuals with disabilities in a state-run facility. And Congress reacted to that by saying we have to do something and we have to create some oversight. And they created the organizations that are called protection and advocacy agencies. And we do a lot of different things, but we are authorized under a set of federal statutes that allow us to investigate abuse and neglect of individuals in different types of facilities, allow us access to records in the facilities themselves, and then we can also pursue administrative, legal, and other relief on behalf of Iowans with disabilities. We serve all types of disabilities, all ages. We have no parameters there, and we never charge for our services because we are funded by federal grants. So just really quickly, the learning objectives for today are, I hope that by the end of this, you really understand what a notice of decision is and where you can find it, that you'll gain some understanding about appealing a decision from a managed care organization or Medicaid fee-for-service, and then you'll learn more about support options and what you can do in this appeal process. So as a Medicaid-focused attorney with Disability Rights Iowa, I really see 3 types of cases most often. I would say first and foremost is the denial, reduction, or termination of long-term supports and services waiver services for my clients. These are things like supported community living, consumer-directed attendant care, respite, things of that nature. The second most common are durable medical equipment denials. So I frequently see wheelchairs, standing frames, safety beds, the accessories that go along with those things. And then third is assistive technology. The most common type that I typically see is speech generating devices for my clients who are nonverbal. So you might want to know, like, how do I know this change is coming? What do I need to be on the lookout for? What might my first clues be? And, if you're dealing with a durable medical equipment case or an assistive technology case, your first clue that you might face some struggles are that a provider may share an experience with you regarding prior authorizations of the same type. For example, when I was doing a lot of speech generating device cases, I was talking to providers who were saying, what we're hearing that these denials are happening really common. I really struggle getting these types of devices approved, even when they're medically necessary. So you might get a heads up from your provider. The other thing that might happen is if your family member is on an HCBS waiver, you might hear something in that care planning process. So a case manager may mention that something's beyond some sort of limit or express concern about prior utilization or lack thereof. We are hearing really commonly right now that if a member failed to use all of a certain type of service in the previous year, that the managed care organizations are a little reluctant to approve the same amount of services in the upcoming year, even though we all know there are lots of different reasons why services might not have been utilized, and it's not always that the member didn't need it. And the other is that maybe you fought a similar reduction in prior years. Unfortunately, I have represented the same clients year after year, multiple times in very similar types of cases. So there is a chance that if you have fought a reduction in a prior year, unfortunately, you may be looking at that again in a future year. So first things first, you are entitled to timely and adequate notice. And I have up on the screen here what that means legally. And this is a lot of words here, but essentially you are entitled to a letter that explains to you what's about to happen and your ways that you might deal with it. So the notice has to come at least 10 days prior to the intended cut or change. I will tell you in recent years, they're coming more often 30 days ahead of time, which is great. And that adverse benefit determination, that's what the notice is called by law, has to tell you the steps the managed care organization has made or intends to make, the reasons why they made that decision, the enrollee's right to request an appeal, how you can do that appeal, the circumstances under which you can do that appeal in an expedited manner, and then your right to continue benefits while the appeal is pending. What I have up here on the screen is the federal law that dictates all of this, but I've also included the Iowa Administrative Code that really mirrors that very closely. So essentially what this means is you should get a letter in the mail. You should always, always, always get this notice in the mail. This is also why it's very important to make sure that your address is up to date with your managed care organization and with the Iowa Department of Health and Human Services. Your case manager, if you have one, may also email you or let you know in advance. You know, sometimes they talk to the utilization teams or there's some sort of med review that they've presented at, that they may be able to give you a heads up that this denial or reduction is coming. But legally, you must always, always get a written copy. Being verbally told is never sufficient. And so that's something I really want to stress, is that the managed care organization cannot cut your services or your family member's services until you've received that timely and adequate notice. So if you get this notice, the first thing is to consider all of the paperwork. Before you do any sort of type of appeal, you want to be prepared. So I always encourage gathering all of the relevant documents to your case. This is the care plans or support plans or person-centered service plans. Each MCO uses a little bit different language, but essentially the plan of care for your family member. Any relevant assessments that have been done. So if you're on the ID waiver, this is going to be the CIS assessment or otherwise the DRI assessment. If you have your current years and your prior years, so you could show some comparison and some changes or not changes, that can be helpful. If you have self-directed services, meaning if you are on the Consumer Choices Option Program, you're going to want a copy of that budget. Any notices or appeals that may have been filed previously, and then relevant medical records or letters from medical professionals. And we can talk about that in more detail later. And then names, numbers, and releases for anybody who might be involved. The more of this you have up front, the better prepared you will be moving along through the process. Okay, so the appeal process. You've got this denial, you've got this reduction. Things are feeling pretty stressful right now, but there are ways for you to handle it. The first things first is to know that that notice of decision you received in the mail, as we mentioned, by law, has to include how to appeal. Now, the really frustrating thing about those notices is that they're often very hefty. There might be 6 or 10 pages inside this envelope because there are all sorts of federally required disclosures and things in other languages. But really what you need is about 2 or 3 pages. That first page is going to be the reduction and the action they're taking or the denial and why they're doing it. And usually the second and third pages are how to appeal. So my biggest piece of advice when you first get that notice and you start getting ready is don't just toss everything but the first page. Keep a hold of that so that you know exactly where to send your appeal. With your managed care organization, whether it's Iowa Total Care or AmeriGroup or Molina, they're going to tell you where to send it. And the law requires that the managed care organization operate a first level appeal process. So essentially, you're going to put together a letter about why you believe the decision isn't correct. I would encourage you to reference back and include those documents we previously talked about. So if it's saying that a certain type of service isn't medically necessary or that your family member can do more of a particular task, really reference those documents that say, well, in the care plan, it says my member needs 24 hours support and supervision, or, my family member needs a lot of assistance with activities of daily living that's demonstrated in the SIS assessment. You have to file this appeal within 60 days. That's really important. You can technically do it by phone, and the notice of decision will include how to do it by phone, but you also have to follow that up in writing. And so I just really, really encourage my clients to always, always just do it in writing. Now that 60 days is the deadline, but if you want continuing benefits, you need to do it within 10 days of receiving that notice or before the cut takes effect, whichever is later. So if you get a notice and it says we're going to reduce your supported community living effective such and such date, but you want to request that those services continue while the appeal is filed, you can do that. You just need to do it more quickly than that 60 days. So you send off that first level appeal decision to your managed care organization, and then you wait. The MCOs have 30 days to come to a decision, and in my experience in the last few years, they really stick to that, which is great. They're required to do so by law, but sometimes because the decisions regarding the appeal come in the mail, it might be 33 days or something like that. But know that it is coming. The decisions have to be made by someone who is not involved in the first decision. And so sometimes you might notice that the initial denial or reduction or termination is signed by a particular doctor. Then the first level appeal decision should be signed by somebody else. Unfortunately, these appeals are often denied. The thing I would really like to stress for you is do not be discouraged. It does not necessarily mean that your case does not have merit or that your family member, your child doesn't deserve these services or they're not legally entitled to them. I have had a lot of really, really good meritorious cases over the last 7 years that have been denied at the first level. So I really, really encourage you to not give up, even if you face that initial roadblock. But if you did get there and you did have that roadblock and that first level appeal was denied, you have another step. And that takes it out of the managed care organization realm and puts it with an administrative law judge. And this is called a state fair hearing. So after that denial that you got from the managed care organization, you have 120 days to appeal that denial and request what's called a state fair hearing. Just so you know, the hearings are by default on the phone. There is nothing wrong with that. It's the administrative law judges sit in Des Moines and they cover the entire state. And so they do most of these hearings on the phone to reduce the need to travel. That being said, if you want your hearing in person, you can absolutely do that. You just need to affirmatively request it. Just like that first initial denial was going to include instructions on how to appeal, the appeal denial is going to include instructions on how to request a hearing. So again, don't just look at that first page that has the disappointing information about your appeal being denied. Go to that second and third page that will tell you how to ask for a state fair hearing. If you have requested continuing benefits during the pendency of that appeal, you're going to need to re-request it and you request for a state fair hearing. And essentially what you do is you send a letter to the Department of Human Services, Health and Human Services now, explaining the need for a hearing and the exhaustion of that first level appeal. And again, the notice that denied your appeal will include instructions on how to do that. I think you can do it online. You can send a letter, or I actually do it by fax in my office, which I know sounds very old school, but allows for that confirmation page, which I really like. And I essentially just explain to the administrator at HHS listen, my client was denied or terminated or reduced these services. We attempted the first level appeal. It was unsuccessful. And for that reason, we're requesting a hearing. When you send that off, you wait a little bit and you will get a form letter back that acknowledges receipt of your request for a state fair hearing. And it will tell you that it is being reviewed to determine if you meet the qualifications for that hearing. Assuming that you have exhausted the first level appeal process and you have an appealable issue, which you will if you are appealing a denial of a service or a piece of equipment, you will then get a letter that tells you your judge assignment, their contact information, and gives you a hearing date and time. So you get this letter, you have your judge assignment, you have your hearing date and time, you're either in person or you have your call-in number, then you need to start preparing. And so the thing to remember is that this is a contested hearing, but it is about as far from law and order as you can imagine. It's a relatively informal process where both sides get to present their information. So I highly encourage that you submit things to the administrative law judge ahead of time that relate to your case. There will be instructions on how to do this when you get your hearing date and time. I will be fully transparent that that letter that comes that gives you your hearing date and time has a lot of information and teeny tiny print on it. So take your time, read through it. The front page will include the hearing date and time, the judge's information like we talked about. You turn that over and there's all sorts of extra information on there, including how to submit your exhibits. I always include the assessments, the care plans, relevant medical records. I think pictures can be really powerful, especially if I'm talking about a piece of equipment. What the situation is currently, what we're trying to work for, especially if you're going to have a phone hearing and so the judge is never going to see you or your family member or your child. I think pictures, if relevant, can be really powerful. Also, letters from providers are really important as well. You put all of that together and that needs to be submitted to the judge 5 business days ahead of time. So it's essentially a week. And the managed care organization will do the same. They typically send their exhibits, their documents, by UPS or FedEx. It comes in a big chunky envelope, typically, not always, but usually. And they will be referenced in there, exhibit A, B, C. And something to keep in mind is they may also submit the assessments or the care plans or things like that. So if Iowa Total Care, for example, has already submitted your child's care plan, you don't need to do it again. But if for whatever reason it's left out, that's important information for you to include. The next thing I do after you gather all the documents is to consult the experts. Talk to as many people as possible who can support your case. So this might be your child's physical therapist or speech language pathologist or the durable medical equipment provider. Maybe it's the support broker if you have self-directed care. Maybe it's the treating physician. It's all going to vary by the type of case and the service that's at issue. But talk to these folks and see what they can do to help support your case. If you're talking about a wheelchair, for example, and the managed care organization is arguing that it's not medically necessary for some reason, then having the physical therapist who wrote the letter of medical necessity with the treating physician testify at hearing can be very, very powerful. When I'm conducting hearings and I talk to the medical providers and the clinical treating specialists, I always say, listen, I'm an attorney, I know the law, but you know the clinical medical needs of my client, your patient that we share. And so the medical providers can be really powerful. That's especially true because I really say that they don't have a dog in that fight, right? Of course, they want what's best for their client and their patient, but a treating physician is not going to financially benefit if the child gets the wheelchair he or she needs, right? So they are a non-biased third party that really just wants what's best, and administrative law judges take that to heart. Now, that being said, if they aren't available to do it in person, if for whatever reason the doctor or the physical therapist can't be present on the phone during the hearing, they can write a letter of support and you can submit that with your other exhibits. Like I mentioned, all hearings are by default on the phone. There is nothing wrong with this. I often counsel my clients who might be nervous about that we have had very good outcomes on the phone. Most of the hearings are done on the phone, and the administrative law judges are really good at it. They're very used to it. Nothing's out of the ordinary for them. So they're very skilled at handling those phone hearings. That being said, don't ever be discouraged or not feel like you can't ask for it in person. I do think there's some value in an ALJ looking at an individual and a family and putting a face to the people who are involved in their decision. But assuming that you're doing it on the phone, you dial in at a certain time, you're given the number and that notice we talked about earlier, and the ALJ will just get on the phone. They'll say, this is ALJ so-and-so, it's this date and this time. They'll make sure that all parties are present. They will see a list of phone numbers. They will go through, make sure everyone who's there needs to be there, kind of take roll call. And then they start the hearing and they put everybody on the record. So this is, they tell you, we're going on the record. This is the official beginning of the hearing. And the managed care organization will present their evidence first because it is their burden to prove that the member doesn't need these services. So they will call whatever witnesses they need to have, or they will present whatever evidence they have. And they will basically tell the judge why they think this particular service should be denied, reduced, terminated, or why a certain piece of equipment shouldn't be approved, and just basically tell their side of the story. You will have the opportunity, if you want it, to cross-examine or ask questions. So you can do that if you want, or you can wait until it's your turn to present your side of the story, essentially. So after the MCO has presented evidence, it's your turn. You can call witnesses. So if you have your child's physical therapist or primary care provider on the phone, that's when you have that person testify and explain their support of whatever is at issue. I would encourage you to reference your exhibits or the documents. So if you are saying, my child needs supportive community living, we discussed this as an interdisciplinary care team, we've planned for it for years, you can see the support for this in my child's care plan or in my family member's DRI assessment. You want the ALJ to have a full understanding of the situation. Administrative law judges hear lots of different types of cases, Medicaid just being one of them. Now, we've been doing this a long time, and so they get it, and they've seen these types of cases frequently, but it's important to remind them what the full picture is. And if you reference certain documents or exhibits during the hearing process, that can encourage them when they're making their decision to go back and look at it. So, they may think, well, the family member said this was all in the care plan. I wonder what else the care plan says. And they're going to, they might spend time with it. So you want to really reference those documents that you believe support your position. After you're given your side, your chance to present, the managed care organization may have some questions for you as well. Both sides get to technically cross-examine. And then the ALJ may have questions. So don't be alarmed or nervous if the ALJ kind of steps in and says, well, wait, how long does it take to do this? Or what would it look like for the process to be that? In my experience, our administrative law judges are very good. They ask good questions. So don't be surprised if they kind of interject, and make sure they clear up any confusion they may have. After both sides are done presenting their evidence, you will have the opportunity to present a closing argument if you want. And then the ALJ will issue their decision in about 30 days. They'll close their record. They'll thank you for being there. They will inform you of what is to come. And then you go home and you wait. After the hearing, you're going to get that decision in about 30 days. It's important to know, and this can be a little discouraging, that the ALJ decisions are technically proposed decisions, meaning that either side can technically appeal to the director of the Department of Human Services. So this means if you win and the managed care organization is unsuccessful, they can appeal that to the director of the Department of Human Services for another level of review. They have to give notice if they're going to do that to the department within 72 hours. The unfortunate thing is they may give the department notice within 72 hours, but then the department sends you a letter. And so you maybe think you're in the clear, but 10 days after you get the decision, you get that notice. So just as a heads up, you have to wait a couple weeks to know if it's final. Alternatively, if you are unsuccessful at the hearing, you can also request a review to the director of the Department of Human Service. And you have 14 days from the date of the decision to do that. And again, instructions get included. You'll get a copy of that proposed decision in the mail, and the first page is your appeal rights. So if you don't like the outcome, you have an appeal option to the director of the Department of Human Services. So everything so far has been about managed care, and that's because 90+% of folks in Iowa who are on Medicaid are on managed care, meaning that they receive their services through a managed care organization. But I know some of you out there are likely on fee-for-service, or you serve members who are fee-for-service who don't have an MCO. So just so you know, if you don't have an MCO, there's no first level appeal. Your appeal rights are to go straight to state fair hearing. All of the other advice I've provided is the same. You want to include the records, you want to have your witnesses, you want to be ready to go with your support. The process is the same. You just don't have to do that first level. So the final thing is, when do I get a lawyer? The first things first are you don't need a lawyer. You can absolutely do these hearings on your own. You're not required to have one, but I would encourage it because we can help. I would encourage that you contact Disability Rights Iowa as soon as possible. Essentially, if you get that notice of decision that says, your managed care organization is reducing or terminating or denying a certain service, contact our intake specialist immediately. The sooner that we can get involved, the better. The only caveat I'll put in there is if you are requesting continuing benefits and the timeline is close, then you're going to want to file that request for continuing benefits and appeal as soon as possible, but also contact DRI and let us know. We may occasionally advise you to file that first level appeal on your own and then come back to us if it's denied and you need to go to hearing. But I also want you all to know that we will consider taking cases that are already set for hearing. It's just more difficult to accommodate. But occasionally someone will contact us and say, we have this hearing date, it's set for such and such a date. Can DRI help? And the answer is typically, if you can get a continuance, meaning if you can ask the judge to reassign your date, we'll absolutely consider it, but we can't promise it. So the sooner that you get us involved, if that's what you're looking for, the better. The other thing that I will share is that our friends at Iowa Legal Aid also do some Medicaid related cases. So you are always welcome to contact them as well. They just have different intake requirement and do have a pretty strict financial limit on where they can provide services, but something to contact and consider as well. So I know I went through a lot of information very quickly. I intentionally like to do this presentation about the first half, the information, and then the second half, questions. So I've reserved lots of time for that. But here is our contact information. You can contact DRI directly at that 2502 number if you want to get a hold of me directly. My extension is 233. But I'm happy to take questions.
Talk about technology. I feel like I just like pushed like 8 buttons when I was trying to push one. So I apologize to everybody about that. If all of a sudden you got like clicked into something and then unclicked. So I have Mari here with us. Um,
Hi, Emily. It looks like we've got a couple questions coming
Perfect.
in. It looks like one of the questions says it's around a situation with a durable medical equipment situation, and where one of the MCOs has approved that DME, and then it was denied by the other MCO when the person switched. So there must have been a switchover in the middle of that. And so the question is, how can one MCO approve and another MCO deny?
So that is a very good question. Without seeing the notices and knowing the situation in more detail, I can't completely speculate, but I can sort of give you some thoughts. So durable medical equipment specifically has some definitions in the Iowa Administrative Code. Durable medical equipment should be approved when it, meets a medical need for a disability or malformed body part. It's a strange language that's in the code, and if it's going to make a significant difference in the member's life. I'm paraphrasing a little bit here since I don't have the code in front of me. And that durable medical equipment has to be both medically necessary and a reasonable expenditure for the Medicaid program. So it's not enough that a member needs a particular type of equipment. It also has to be basically financially reasonable. And so those are the things that get considered. And I will just say something that we fight with the MCOs about, me at DRI as an attorney, is I think the MCOs, in fact, I know they do, rely on internal policies that they have written. So Iowa Total Care and AmeriGroup have parent organizations, bigger companies ahead of them, and they have certain written policies about when they approve certain pieces of equipment. We often fight about those policies in appeals and hearings. And so if I had to speculate, if I had to guess, one managed care organization, one managed care organization's medical director reviewed the information, thought it was necessary when they considered everything. And it sounds like the next one didn't, maybe taking those internal policies into consideration. This sounds like one I would highly recommend contacting our intake on if you're interested. But if you do go through the appeal process with the new MCO, definitely point out that a prior MCO approved this and thought it was medically necessary. I think that's pretty powerful evidence.
Thank you. It looks like we have a kind of follow-up to that where the person's describing how they might be going through the process of appealing and getting that first denial and going through that, scheduling the state fair hearing, but then the MCO approves, makes the approval just barely prior to the hearing. And so it's just a lot of delays, it sounds like. And so any suggestions on how to facilitate the process?
I wish I had better advice. That's extraordinarily common. I should count at the end of every year how many state fair hearings I prepare for, and then how many I actually end up doing, because the number is very different. I really hate that this is the case, but it's extraordinarily common to get to the week before or even the day before. I even had one the morning of, where honestly, I think the managed care organizations, they start to sit down and really prepare for that hearing. And then they realize this person has all the evidence in the world to support their need, and it gets turned around at the last minute. It's always great that my client gets what they need, but it makes me frustrated because this could have been done weeks, if not months before. The one thing that I can encourage you is you can keep going back to the managed care organization. Sometimes I do that, like especially if it's just so clear that my client's entitled to these services. I might contact the appeals department and say, hey, as a heads up, here's what we have. Here's what I'm going to submit at hearing. Is there anything we can do to discuss ahead of time? You can technically ask Under the law, you can ask for a pre-hearing conference with the other party. You don't always get it. But it doesn't hurt to keep going back and saying, listen, what can we do to keep talking about this? Because sometimes it can help facilitate a response a little sooner, but unfortunately, those last minute turnarounds are pretty common.
Right. Well, just a reminder, if you have any questions, please put them in chat. This is kind of the time that we are able to work through some of those. Otherwise, Emily, thank you so very much for presenting today. This has been just a wonderful wealth of knowledge. I'm so very excited that we'll be able to share this out in the future, and people will be able to access it on YouTube so that as they're going through the process, they can remind themselves of all these valuable steps that you've given them. Those of you that are attending, we're going to drop into the chat the survey that I at the beginning talked about for you to complete. This will also come to you through email if you'd like to fill it out that way. This again allows us just to continue to do presentations like this, do webinars, continue to educate families and professionals that serve them and how to navigate some of these very intricate systems. Law, obviously, probably being the number one that most of us have no comprehension of where to even start with. Also, just letting everybody know, like and subscribe us on YouTube channel. That way you can find this webinar and also future webinars. Also look on Facebook, there's some daily tips. And also if you go to our events tab on askresource.com, it will tell you other webinars that we are hosting in the future and other trainings and events that we have going on. So we'll take a minute here just in case anybody had a thought that came to them at the last minute. Otherwise, everybody, thank you for attending and have a fantastic day. Oh, it does look like we do have another one that just popped in. It says, in requests for CCO services, is the case manager able to state that they think that it's already at limit verbally and essentially request not to submit so there's no adverse benefit determination generated?
My advice on that is to push, and ask for that notice of decision. Without knowing the situation in more detail, I can't provide specific advice, and there are certain services that have certain limits, especially for members of certain ages. But it hurts nothing at all to push and say, you know what, I hear you. I'm going to really need you to submit this request though, and get a notice on that. And that will help inform your next steps if there truly is a limit. Because I will tell you, sometimes the limit's legitimate and sometimes it's not. And so if you push and get that notice, that can help you decide and inform next steps. So I'll say it again, push for that notice, push for that notice. It's very important.
Okay. Answered.
Something else I just saw in the chat, I think this is the same DME question, or regarding a recent question, but the peer-to-peer that's done between the MCO and a medical provider, don't let that discourage you from also doing the appeal process. There is no harm in doing the peer-to-peer. But I work with a lot of providers who talk about their frustration with that peer-to-peer process, and there's no appeal process from the peer-to-peer process. So both things can be done simultaneously. So fantastic if you have a provider doing a peer-to-peer, but don't also not appeal. There we go.
So someone is also asking, is there a booklet or flyer that we can give to our patients?
Okay, that's a great question. So when managed care first came into Iowa 7-ish years ago, a lot of advocates did put together a big pamphlet, a big booklet that was included. It included a lot of really good information. Obviously, a lot about managed care has changed over the last 7 years. And so everything in there is not as accurate as it once was. So I'm hesitant to massively distribute it, even though there's still good information in there. I am also working on a Medicaid appeal fact sheet that will then eventually be posted on our website. So stay tuned because that is coming. And something that DRI does is we also give technical assistance to providers as well. So if you are working with a member who's working through an appeal process, you are also welcome to contact our intake. And sometimes I just do these hour-long phone calls with other professionals to help support a member through the process.
Perfect. Well, yes, when you have created that, we will make sure that we also are sharing that out so that everybody can make sure that they're finding access to that.
Perfect.
That sounds great. Okay.
Thank you for having me. This was,
Yes.
I can talk about Medicaid all day long. So thank you very, very much for the invitation.